Thanks for joining us for the November episode of Kelleher and Holland's monthly Lunch and Learn webinars. My name is Zach. I work in the marketing department here at Kelleher and Holland, and today's topic is regarding the new thresholds for federal exempt employee classifications. Before we get started, if you have a question at any time during the webinar, please type it in the Q&A box located in your Zoom control panel, and we will address them at the end of today's presentation. We have a perfect blend of panelists today from our employment law group, Andy Bowling and Madeline Kelleher. Before we get started, do either of you have a favorite coffee or tea drink?
Sure. Yeah, I am a matcha person, so I usually get my venti matcha latte with sway at Starbucks.
And I like all kinds of coffee, but I guess my favorite is a cappuccino with a double shot.
All right, going strong. All right, well, let's get started today by defining the Fair Labor Standards Act. Madeline, what is that?
Yeah, so the Fair Labor Standards Act, or the FLSA, is a federal law that was enacted in 1938 and is enforced by the United States Department of Labor's Wage and Hour Division. The FLSA establishes minimum wage, overtime pay, record-keeping requirements, and child labor standards. So in order for the FLSA to apply, there must be an employment relationship between the employer and employee. So almost every employee in the United States is covered by the FLSA, as it affects both the private and public sectors. That's a good little synopsis of what the FLSA is.
Okay. Well, Madeline, does the FLSA define all terms and conditions of employment?
No. So this is a common misperception of the scope of the FLSA. Even though every employer, or almost every employee, is covered. So, for example, it does not require paid time off, meal or rest periods, pay raises, or fringe benefits. But always check your state and local laws for these types of requirements, as some states require such conditions of employment. Rather, the FLSA is geared specifically towards minimum wage, overtime pay, record keeping, and child labor. So let's go over some of the current applicable rules. As for minimum wage, the current federal minimum wage is $7.25 per hour and has been so since July of 2009. Tipped employees, meaning those engaged in the occupation or in an occupation in which the employee customarily and regularly receives more than $30 per month in tips, must be paid $2.13 per hour if the employee's tips combined with this lower minimum wage does not equal the minimum wage of $7.25 per hour, then the employer must make up the difference. So we've got $2.13 per hour with tips, and if it doesn't equal $7.25 in the end, then the employer has to make up the difference. Additionally, covered employees must be paid for all hours worked in a work week. Generally, compensable hours worked include all time the employee is on duty or at a prescribed place of work, and any time that the employee is quote unquote suffered or permitted to work, meaning work past normal business hours or during times the employee is supposed to be off the clock. So then it would generally include work performed at home, travel time, waiting time, training time during work hours, and probationary periods. For example, workers must be completely relieved of duty for a meal period so that it wouldn't be considered compensable work time that needs to be paid. As for overtime, a covered non-exempt employee must be paid overtime at a rate of 1.5 times the employee's regular rate of pay for all hours worked over 40 hours a week. All that time that is worked must be counted when determining these overtime hours. There are some workers who are classified as exempt from the FLSA overtime pay requirements, including, for example, executives, administrative workers, professionals, computer workers, highly compensated employees, and those not in outside sales, not in outload sales. So the commonly exempt professions would, for example, include a CEO, human resources managers, teachers, accountants, executive chefs, doctors, computer engineers, lawyers, and the list goes on. So there's a way you have to determine whether they're exempt or not, though. Generally, exempt employees must currently make no less than $684 per week, which would come out to approximately $35,600 a year. And they have to have duties that fall within a duties test, which Andy will discuss in detail in a few minutes. As for record-keeping requirements, employers must display an official poster outlining the requirements of the FLSA in a place in the business where employees would see it, such as, for example, the kitchen, where all the employees go into. The employer must also keep employee time records and pay records for specific minimum numbers of years, and it depends on the type of record. As for child labor, the FLSA regulates the employment of youth, including the jobs they can do at certain ages and the hours that they can actually perform this work at, depending on the age. These provisions are designed to protect the educational opportunities of minors and prohibit their employment in jobs and conditions that would be detrimental to their health or well-being. Something to note is that different rules apply to youth employed in agriculture. And that's a pretty good summary of what the current regulations are that the FLSA covers.
Okay, so Madeline, does the FLSA override state laws?
Yes and no. So the FLSA sets a floor, so a minimum protections that regarding overtime, record keeping, minimum wage, and child labor. So no state can impose reduced rights than those protected under the FLSA, but states can't, and local governments can legally require more generous treatment to employees and more generous requirements. Employers must always follow the law that provides the greatest protection for the workers. Many states, counties, and even cities have their own wage and hour laws that they regulate and enforce. Some are similar to the FLSA, but some differ, and as I just mentioned, are more employee friendly. The key local and state wage laws to monitor are those regarding salary levels for exempt employees, meal and rest breaks, timing of final paychecks, vacation time and paid time off, bonuses and commissions, and wage notices.
Okay, so Andy, could you break down for us the specific changes the Department of Labor is proposing?
Happy to do that, Zach. And just like everything else these days, the upshot of what the DOL is proposing to do is to have employers pay more for the same. Essentially, the crux of the Department of Labor's proposed change is to increase the minimum salary necessary to qualify for exempt status under the three traditional exempt categories of under wage and hour law, excuse me, executive, administrative, and professional employees. And the current minimum is $684 per week, roughly a little over $35,000 annualized. And this will increase to at least $1,059 per week, or just over $55,000 on an annual basis. Could be higher, as I'll talk about in just a minute. Now, how does the Department of Labor get this data? Do they just pull it out of thin air? It might seem that way, but actually there is a method to their thinking. And traditionally, the Department of Labor has looked at base wages that are published regularly by the by the Bureau of Census and the Department of Labor, the Bureau of Labor Statistics. And so they set the standard salary level at the 35th percentile of weekly earnings of full-time salaried workers in the lowest wage census region, which is currently the southern region of the United States. Typically, the Department of Labor does not include kind of outliers like the state of Alaska, Hawaii, or some of the Commonwealth countries, the Mariana Islands, Puerto Rico, when making these determinations. The final amount will be pegged at fourth quarter data for year 2023. So that information isn't even calculable yet. But some economists have estimated that this could be as high as $1,158 per week, or just over $60,000 on an annualized basis. So what else is happening? To summarize briefly, increasing the minimum salary level for exempt, executive, administrative, and highly compensated professionals. Then there is this other category of highly compensated employee that we'll call HCE. Now, the HCE covers highly paid employees, obviously, but who don't quite qualify for any other exemption. And to the current baseline level is $107,432. This would increase to $143,988 if the rule goes through. The current HCE minimum was calculated in 2019 using the 80th percentile of full-time salaried workers on a national basis. So unlike the traditional exemptions that focus on a portion of our country, the lowest wage rate in our country, HCE is based on all 50 states. And this new test would increase the annualized weekly earnings of the 85th percentile from 80 to the 85th percentile. And again, this current number, projected number of $143,988 is really based on 2002 data. So the rule could very well change once we have 2023 data that is actually in place. Another change. Currently, any change to the base level requires a special proposed rule, as we are seeing now from the Department of Labor. Under the proposed rule, there will be automatic increases every 3 years to each of the 4 categories that we're talking about based on prior year data. Here's a really important thing to remember. The only thing that is changing here is the dollar amount, the minimum dollar amount that must be paid to make sure someone is ineligible for overtime. The actual legal standards that are employed will not be changing. And so, kind of confusing as it is, it'll remain confusing, but at least there aren't new rules that have to be learned for employers. Now, you might ask, when will this happen? Probably going to happen sometime between January 1, 2024, or perhaps even end of first quarter 2024. Hasn't happened yet. Under the administrative law rulemaking process, the department officially announced their proposal on September 7, and today, November 7, is the final day for anybody who cares, one way or another, to submit their comments to the order. Again, we expect that this will be implemented on January 2024, but we also anticipate that there will be legal challenges to this rulemaking. The last time the Department of Labor tried to do this as to executive, administrative, and professional exemptions was in 2019 by the Obama administration, where they tried to raise the level from the current 684 to 913, and that was shut down after a lawsuit was filed in a Texas federal district court. So we expect that once the Department of Labor says, time's up, here's our rule, that business groups will coordinate legal filings in what they perceive to be business-friendly locations, such as Texas, such as Florida, in order to challenge the rule.
Okay, thanks, Andy. And as you mentioned, there will be no change to the duties test for exempt status under FLSA. So could you provide a short summary of each exemption?
Sure. Let's start with the executive level exemption first. And each of these exemptions currently requires a minimum weekly salary of $684 per week. Now, in addition to satisfying the minimum salary test, if you want to be exempt as an executive, the executive's primary duty must consist of the management of the business or a department or subdivision of the business. Department of Labor uses the term enterprise for business, but it really means business. And in addition, you customarily and regularly direct the work of 2 or more employees. And what does this mean, to have this authority? It means you have the authority to hire or fire employees or make recommendations as to hiring, firing, advancement, promotion, change of status that are given particular weight by the people who actually have that final authority. There's one limited exception for executives. If you make the minimum salary level, whether it's $684 today or over $1,000 in 2024, if the executive owns 20% or more of the equity in the business and is actively engaged in the day-to-day management of the company, that's all you need to satisfy. The second category is administrative workers, and we probably see more litigation, enforcement, and disputes surrounding this very broad level of classification. Again, minimum salary threshold, currently $684 a week. And then we dive into the duties, and this is different from the categories for executive level employees. An administrative worker will be exempt if their primary duty is the performance of office or non-manual work directly related to management policies or general business operations, and you exercise discretion and independent judgment with regard to matters of significance. In other words, someone who is exempt on an administrative basis can't just follow a binder or a playbook with no authority to deviate from the binder or the playbook. You have to have the ability to interpret and make ad hoc decisions using their informed judgment. And this is, the category that often applies to a lot of assistant managers in restaurants or in other business operations where it's not clear that the person actually has the authority to manage 2 or more employees. The third category is the professional exemption. And actually, within this, there are 2 subcategories of workers who can be considered exempt on a professional basis. There is the learned professional employee exemption, which requires, again, the minimum salary, currently $684 a week. And then the primary duty of an exempt professional must consist of work requiring knowledge of an advanced type in a field of science or learning customarily acquired by a prolonged course of specialized intellectual instruction and study. And in addition to satisfying those educational requirements, you must consistently exercise discretion and judgment. Who falls within such categories? Typical examples are physicians, attorneys, accountants, many engineers. So that's the learned professional. And then there's this other category of creative professionals, which again must be paid on a salary basis of at least $684 a week, subject to an increase in 2024. And their primary duty must be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. And who does this cover? Some, but not all, journalists. If you're the opinion or an editorial writer, you probably might qualify. But if you're just gathering facts and spitting them back to someone else who's putting them into a story, you may not. So be very careful if you're dealing with musicians, artists, writers, journalists for this creative professional. Finally, we'll talk about highly compensated employees. They are exempt if they make the current minimum of $107,000, $432, and they are paid at least $684 per week on an unrestricted, unconditional salary basis. The balance of that pay can be in the form of bonuses and commissions, but there must be a minimum weekly payment equal to the minimum required for executive, administrative, and professional. Now, this highly compensated employee exemption doesn't apply to just everybody who earns that salary. You must perform office or non-manual work. So in other words, you may be a really skilled carpenter, and you're doing those skills in the field, you wouldn't qualify because they're doing manual work. You must also customarily and regularly perform at least one of the exempt duties or responsibilities of an executive, administrative, or professional employee.
So all of this sounds pretty complicated, Andy. Are there any traps that employers should avoid?
Yes, and Zach, you're absolutely right. Sadly, these rules were written by lawyers. They may seem short, but they're designed to be confusing, to create work for more lawyers and headaches for business. That's just the way it seems to go. But here are some mistakes that I've seen over my career that are pretty common and can create big headaches for employers. One, the employee is paid hourly, not on a fixed salary, or they're paid less than the minimum salary threshold. Another common pitfall is the job title alone was used to determine exempt status. You may give someone a very fancy job title, Executive Vice President of XYZ, but if they're actually doing non-executive work and they don't satisfy the substantive test, that fancy title doesn't mean anything. The Department of Labor very much uses a substance over form or title in determining whether someone is eligible for an exemption. Another pitfall is following a job description. Maybe the job description is written poorly in the first place so that it creates doubt on the legitimacy of an exemption. But more often, the job description may be written so as to make the employee exempt, but their day-to-day duties don't align with the content of the job description. Another pitfall, looking at educational status. Well, this person has a college degree. Clearly, they're exempt, and it would be an insult to call them non-exempt. College degree doesn't mean anything unless it's one of the components for the limited learned profession. It's not going to help you at all in the executive or administrative ranking. Another is simply relying on a high salary alone. Well, this person makes maybe an amount under the HCE minimum, but well above the minimum for executive or administrative, doesn't mean anything. You have to satisfy the duties. Another common pitfall is you may have all your ducks in a row, everything is aligned, but then your day-to-day HR practices are such that you don't treat exempt employees as exempt employees. And where does this often arise? In the context of, well, we're going to take a deduction. You missed a half day of work unexcused. We're going to cut your pay for that particular work week. Or you make inappropriate disciplinary deductions. You can't do that in most cases for exempt employees. If you're going to dock an exempt employee's wages in any way, I strongly suggest you study hard with your HR professional or an attorney to make sure that you can do what you want to do. And then the final trap is, well, we've looked at the federal level, we looked at the FLSA, and we're golden, but you might be in a state where, as Madeline said, yeah, you satisfied the floor, but actually there's another floor created by state law, and you're not even close to meeting that requirement. So those are some common pitfalls.
Okay, great. Thank you, Andy. And Madeline, are there any key takeaways or to-go cups for our listeners?
Yes, of course. The key takeaways from today's presentation are: monitor the new regulation. Make sure you know when they're coming out and what they are. Make sure to work, another one would be to make sure you work with your attorney to conduct a privilege audit of your employee classifications for exempt versus non-exempt status. And don't forget about state and local laws. For example, California and Washington have much higher standards for exempt employee threshold. In California, it's over 64,000 for large employers, and in Washington, it's over 65,000. Those are the most important takeaways from today.
Great. Thanks so much. And it looks like we may have time for one question. I see one here. If the proposal becomes final, what should my company do if my exempt employees' salaries are below the new minimum?
Well, if that happens, I think you would generally have two options. First is to reclassify the employees as non-exempt and pay them overtime whenever they work more than 40 hours in a work week. I think the more practical option is probably door number two, and that is raise the salary to meet the new requirement. And frankly, let's be, really transparent here. The salary minimums for exempt status, which are many years old, were largely made irrelevant in many high-cost jurisdictions, Chicagoland area, New York, California, large cities, by shortage of workers over the last several years. So if you are below these new levels, maybe the best approach is simply to raise the salary. The employee will be happy to have a raise, and you won't have to look at potential past liability for misclassifying the worker if you change their status to non-exempt.
Great. All right. Thank you, Andy. I think that wraps it up for today. We're getting pretty close on time. So we hope that you had an informative session for all those listening, and we thank you all for attending. You can contact our speakers directly if you have additional questions about today's topic. Their contact info is on the screen now, and they'd be happy to answer them offline. Our last Lunch and Learn for 2023 will be Tuesday, December 5th. We'll be discussing the impact of the National Labor Relations Board's final joint employer rules and the employment issues bundled in President Biden's executive order on artificial intelligence. Registration for this session will open soon, so check your inboxes or our social media pages for more information. And we hope that you all have a great rest of your day.